Waqf is the permanent dedication of property, land, buildings, or even funds for a religious or charitable purpose. Think of it as an endowment, but with a vital difference. The property's ownership is essentially transferred to God. Once designated as a waqf, the property becomes inalienable, held perpetually for the intended charitable or religious cause. The Waqf Board is presently India's third largest landowner. Numerous disputes have arisen from the board's assertion of ownership over various properties, leading to accusations of arbitrary claims and in some cases significant communal tensions. The Waqf Amendment Bill introduced in India has sparked significant debate. While aiming to streamline Waqf administration, it raises crucial constitutional questions. Today we explore Waqf, a concept deeply rooted in Islamic tradition and practiced globally. Often misunderstood, Waqf represents more than just religious charity. It's a powerful mechanism for social good. Simply put, Waqf is the permanent dedication of property, land, buildings, or even funds for a religious or charitable purpose. Think of it as an endowment, but with a vital difference. The property's ownership is essentially transferred to God, ensuring its perpetual use for the benefit of others. These purposes can include maintaining mosques or even graveyards, establishing educational institutions, healthcare facilities, or providing financial aid to the needy and the disabled. In India, Waqf can be established through a formal declaration, which could be written or oral, long-term use for charitable purposes, or even through inheritance. A person creating the Waqf is called the Wakif and the administrator is called the Mutawalli. Interestingly, while rooted in Islamic principles, the Wakif, that is the person creating the Waqf, does not necessarily need to be a Muslim. Belief in the underlying principle is sufficient. The only requirements are sound mind and legal ownership of the property. Once designated as a Waqf, the property becomes inalienable, held perpetually for the intended charitable or religious cause. Waqfs can either be public, benefiting the wider community, or could be private, benefiting the Wakif's direct descendants or a closed group of beneficiaries. As of September 2024, India had approximately 8.7 lakh registered immovable Waqf properties. As per the Standing Committee on Social Justice and Empowerment, in a 2014 report, most states had not completed the survey of Waqf properties. And as per the Ministry of Minority Affairs, India has the largest Waqf holding in the world. The Sajan Committee in 2006 estimated the market value of Waqf properties at 1.2 lakh crores, and today it has grown in a multitude proportion. Creation and management of Waqf in India is governed by the Waqf Act of 1995. A Waqf Board is a legal entity capable of acquiring, holding, and transferring property, and it can sue and be sued in a court. Each state has a Waqf Board led by a chairperson, including nominees from the state government, Muslim legislators, parliamentarians, members of the State Bar Council, Islamic scholars, and Mutawallis of Waqf, which have an annual income of 1 lakh or more. Waqf Board administers Waqf properties, recovers lost Waqf properties, and sanctions the transfer of immovable Waqf properties through sale, gift, mortgage, exchange, or lease, with at least 2/3 of the board members voting in favor of the transaction. The board appoints custodians to ensure that Waqf and its revenues are used for the designated purposes. The Central Waqf Council, or the CWC, established in 1964, oversees and advises state-level Waqf boards across the country. The Waqf Board is presently India's third largest landowner, trailing only behind the armed forces and the Indian Railways. A property can become a Waqf property through donation by a deed, or if the property has been long used for a religious or charitable purposes, it could be deemed as Waqf property. A non-Muslim, as I said, can also create a Waqf provided that the said individual professes Islam and the objective of creating Waqf has to be Islamic. Section 40 of the Waqf Act grants the Waqf Board the authority to investigate and determine whether a property constitutes Waqf property. While the board's decisions are generally considered final, subject only to challenge in a Waqf tribunal, the Supreme Court has clarified that these investigations must adhere strictly to the principles of natural justice, ensuring that affected parties receive a fair hearing. The board is empowered to gather information regarding any property that it suspects to be Waqf property. However, the broad scope of this power has proven controversial. Numerous disputes have arisen from the board's assertion of ownership over various properties, leading to accusations of arbitrary claims and in some cases significant communal tensions. These controversies highlight the potential for misrepresentation and misinterpretation of Section 40, granting the Waqf Board potentially unchecked powers to claim ownership of land with serious implications for property rights and social harmony. Therefore, a careful and judicious application of Section 40, strictly adhering to the principles of natural justice and transparency, is crucial to prevent future disputes and maintain public trust. Disputes over Waqf Board land claims are causing significant problems in India. Take for example the Tiruchenturai village Tamil Nadu case, where a farmer Rajagopal was prevented from selling his land due to a Waqf Board claim on the entire village, causing financial hardship and communal tension. The board's attempt to assign zero value to Waqf properties to prevent illegal transactions has been temporarily blocked. But separately, for example, in Surat, a plot owner's unilateral designation of his property as Waqf led to its use as a mosque, highlighting the potential for such action to disrupt existing communities without the consent of other residents. These cases illustrate the need for clearer regulation and processes concerning Waqf property claims to protect individual rights and prevent social unrest. The Waqf Tribunal resolves disputes relating to Waqf property. The board, the Mutawalli, that's the trustee, or any other aggrieved party can petition the tribunal for a final decision on the status of the property as Waqf property. Section 83 outlines the tribunal's composition. A chairman, a state judicial service member of district and sessions judge or a civil judge class 1 rank, a member nominated from the state government, from the state civil services, equivalent rank to that of an additional district magistrate, and a member with expertise in Muslim law. The tribunal's decisions are final and unappealable except via judicial review through a process of writ petitions in the High Court, a review to assess the correctness, legality, or propriety of the tribunal's determination. Waqf law shows variations across the world. Indonesia, UAE, and Malaysia have their own set of rules. All these three countries recognize Waqf creation by individuals, with Indonesia and UAE also allowing legal entities to create Waqf properties. Indonesia and Malaysia recognize Waqf by declaration and to heirs, while UAE adds family and joint family Waqf types as well. Administration differs significantly too. Indonesia uses a Waqf body, the UAE uses individual trustees or Emirates Endowment Authority, and Malaysia vests control in a council. Dispute resolutions also vary, with Indonesia favoring mediation and arbitration, UAE using courts, and Malaysia employing the Sharia court and the State Fatwa Committee. But Waqf is not prevalent in Islamic countries like Turkey, Libya, Egypt, Sudan, Lebanon, Syria, Jordan, Tunisia, and even Iraq. Of late, a lot of debate has been garnered around the Waqf Amendment Bill of 2024. Two significant bills impacting Waqf management in India were introduced in the Lok Sabha on August 8, 2024. The Waqf Amendment Bill and the Musalman Waqf Repeal Bill aim to modernize Waqf administration and property management. These amendments significantly alter the composition and powers of the Central Waqf Council and Waqf Boards. A key change is the inclusion of non-Muslim members in these bodies, promoting greater inclusivity and transparency. The bill replaces the survey commissioner with the district collector for Waqf property surveys. Importantly, government land mistakenly identifies as Waqf will be returned to government control, and the collector will determine ownership and update revenue records. The bill removes the previously absolute finality of Waqf tribunal decisions, allowing a direct appeal to the High Court. Other significant changes include stricter criteria for Waqf creation, requiring 5 years of practicing Islam and a clear ownership of the property. Section 40 of the existing Act, which allowed the Waqf Board to claim land, has been deleted completely. The bill mandates 2 non-Muslim members in the Waqf Board alongside specific representation for Shia, Sunni, and backward class Muslims, including at least 2 women. The tribunals will now comprise of a former or current district judge and a state government officer. Appeals against the tribunal's decision are now to the High Court and to be appealed within a period of 90 days. The Waqf Amendment Bill introduced in India has sparked significant debate. While aiming to streamline Waqf administration, it raises crucial constitutional question. A central concern revolves around the reduction of Muslim representation in Waqf governance, as the bill allows non-Muslim majorities in Waqf governing bodies, potentially violating Article 26 of the Constitution, which guarantees religious communities the right to manage their own affairs. This contrasts with the governance of other religious institutions where administrators typically share the same faith. Further concerns arise from the removal of the Muslim law expert from Waqf tribunal. This raises questions about the fairness and accuracy of judgments in disputes involving Islamic law. Additionally, the bill's requirement that a Waqf creator must have practiced Islam for at least 5 years may violate Article 14 and the right to equality unless a clear public purpose for this distinction can be demonstrated. The bill also contains certain drafting inconsistencies. These complexities highlight the need for a careful consideration of the bill's potential impact on religious freedoms, equal rights, and the effective administration of Waqf properties. The debate underscores the delicate balance between modernization, transparency, and upholding constitutional guarantees. At any event, the Waqf law required change in this country, and the hope is that the change will be balanced and will be transparent.